Hello everyone, my name is Shivangi Tiwari and I'm from Hidayatullah National Law University. Today in this video, I'll be dealing with transfer of cases uh, in different courts of the country like Supreme Court of India, High Courts, then the Sessions Courts, and finally I'll be dealing with withdrawal of cases and appeals by Sessions Court. So firstly, section 406 to section 411 of chapter 31 of the code of criminal procedure contains the provisions relating to transfer of criminal cases. Now we'll be dealing with transfer of cases and appeals by Supreme Court. So section 406 of the code confers the power upon the Supreme Court to transfer cases and appeals. The court grants the widest discretionary power to the Supreme Court to transfer any case or appeal which is lying before the High Court to any other court in the country in order to meet the ends of justice. The application requesting the transfer of any case of appeal pending before High Court can be moved to Supreme Court by three types of persons. Firstly, a person who is under apprehension of unfair trial by the court. Secondly, a person who is unable to find a proper justice being served to himself. And thirdly, Attorney General or Advocate General of India. The power granted by the court under section 406 of to the Supreme Court is purely discretionary in nature, and the applicant is under no obligation to conclusively establish that in case the transfer does not take place, then fair justice is just not possible. And in this case, the applicant is only expected to reasonably substantiate the contentions which are made by him under the application which he has submitted to the Supreme Court. Now we'll be dealing with transfer of cases and appeals by High Court, which are contained under section 407 of the Code of Criminal Procedure, which empowers the High Court to transfer the cases and appeals. Subsection 3 to subsection 5 of section 407 of the code lays down the procedures which has to be followed by a person who is making application for the transfer of appeals and cases. The High Court has the authority to transfer the cases when it is satisfied with certain facts. Firstly, the court should be satisfied that the right to fair and impartial trial, which is guaranteed under Article 21 of the Constitution as fundamental right to citizens, can not be exercised by any of the parties to the suit. Secondly, if the High Court is satisfied with the fact that certain questions pertaining to present matter in the court are of unusual difficulty. Thirdly, the court should be satisfied that the transfer of appeal or case is made inevitable by the provisions contained under the code. And lastly, the order of transfer will be in the interest of general convenience of the parties and witnesses who are involved in the suit. Now, under section 407, the saving clause is subsection 9 of section 407. It provides that nothing contained under section 407 of the code shall have any effect on the orders which are passed by Government of India under section 197 of the code, which prevents the courts from taking cognizance of any case which involves the criminal charges against any public servant until and unless a previous sanction of the competent authorities have been obtained. Now we'll be dealing with transfer of cases and appeals by sessions judges. So the sessions judges are also conferred with the power to transfer cases and appeals by the code under section 408. So subsection 1 of section 408 provides that whenever a sessions judge find it expedient to transfer a case to meet the ends of justice, he may transfer such case from one criminal court to another within the sessions division. Subsection 2 of the code, subsection 2 of the section 408 provides that the instances on which the sessions court can transfer the cases. The section provides that the authority to transfer the cases with the sessions court can be exercised by it only at the instance of reports in this regard which are submitted to it by the lower courts, or application in this regard is submitted by the interested party, or the court also has the discretion to exercise such power as and when it feels it necessary to be exercised. Lastly, we'll be dealing with withdrawal of cases and appeals by sessions judges. Section 409 of the Code of Criminal Procedure contains the provisions regarding the power of sessions judges to withdraw the cases and appeals. Subsection 1 provides, subsection 1 of section 409 provides that the sessions judges not only has the power to withdraw any case or appeal, but they also has a power to recall any case or appeal which he had earlier transferred to any additional sessions judge or chief judicial magistrate who is subordinate to him. Subsection 2 of section 409 provides that the power of recalling the cases by sessions judges from any additional sessions judge can be exercised by him at any time before the commencement of the trial of the case or hearing of appeal before the court of additional sessions judge. Subsection 3 provides that the course of actions which can be followed by sessions court if it exercises the power vested on it by subsection 1 and subsection 2 of the section. Accordingly, after the recall of an appeal is made by the sessions judge, he may either try the case or hear the appeal on his own, or he also has the power to transfer the case again to some other court in order with provisions in accordance with the provisions of the code. Likewise, section 410 and section 411 of the Code of Criminal Procedure contains provisions regarding the withdrawal of cases by judicial magistrate and executive magistrate respectively. That was all for today's video. I hope you find this video helpful. Thank you.